The court has always characterized its approach to the grant of a temporary injunction using three factors: the existence of a prima facie case, balance of convenience, and irreparable hardship. Let's look at each of these factors. What does one mean by a prima facie case? This by itself is a pretty ambiguous expression, and it can mean different levels of convincing required on the part of the plaintiff. Is it a strong prima facie case or is it a weak one? The various degrees of proof required to establish these different levels of standard within the same terminology make it a pretty fascinating area of discussion in itself. Now, looking at intellectual property rights, as I mentioned earlier, a lot of the adjudication happens very early on because nobody has the time to wait. The court has to arrive at some strong view regarding the merits of the case, regarding who deserves to win, very early on, because the value, as I said, the shelf life of the property is pretty limited. Moreover, if the court were to refuse to grant an injunction when there is already an intellectual property right vested with someone, that could result in the right itself being rendered absolutely redundant. So these are various factors that the court does keep in mind when considering the injunction application. And prima facie case, to that extent, is largely a strong prima facie case in the case of intellectual property rights, because the court has to strike a balance between, one, the interests of the intellectual property rights owner and ensuring that his property right is not rendered redundant, and two, that it is not a frivolous case and no defendant is put in a hapless position where he is unable to do something just because there is, on the face of it, an intellectual property right enjoyed by the plaintiff. So, coming back to our hypothetical, it is not enough for the court to arrive at a conclusion that there is copyright in respect of film X and which is enjoyed by A. The court will also have to arrive at some prima facie conclusion that the film Z is indeed a remake of film X. And this cannot be a weak indication, because by arriving at this conclusion, the court is almost going to restrain the release of film Z. And if it is doing so, it better be convinced, at least to a strong degree of certainty, before granting such an order. So, as far as the prima facie case is concerned, the court does normally prefer a strong showing of prima facie case, a strong showing of existence of the intellectual property right, and a strong showing of infringement of that right by the defendant. Of course, this will not be a watertight showing because the court does not have any of the evidence yet before it. It is only looking at affidavit evidence, conduct of the parties, and basing its judgment on that. The next part of the test is to look at the balance of convenience. Now, what really is the balance of convenience, or to be more correct in our characterization of this part of the test, balance of inconvenience? The real question here is who is inconvenienced more by the conduct of the other party, and who is inconvenienced less by the grant of the injunction or the refusal, as the case may be. So, in other words, you take the plaintiff, look at what hardship or inconvenience will be caused to the plaintiff where the injunction refused. Then take the defendant and look at the hardship caused to the defendant if the injunction were to be granted. You compare and contrast these. Again, look at the conduct of the parties. Look at who on balance has shown better conduct. So the most important part of this test is of course focused on the consequences, but the conduct is not immaterial. And why is this so? It is so because injunction has always been an equitable remedy. It works based on the equities of the case at hand. For instance, if A, in the hypothetical given here, was aware of B making Z for the past 6 months and did not approach court or contact B relating to the making of film Z, A decided to sit and wait and watch. This could result in a classic rent-seeking problem. When right at the last moment, when B is about to release his movie, A lifts his hand up and says, "Come on, look at me, I have got an intellectual property right here. But what were you doing for the last 6 months?" So delay can be an extenuating factor which can work in favor of the defendant. And the court may very well tell A that you didn't act at the right time. Or A were to approach the court without disclosing all the facts. For instance, the fact that there is no assignment of the script in favor of A by the script writer of film X is a factor that can heavily weigh against A, because he is then not the right owner at all. But were he to conceal this and try for an injunction, that's a factor that the court can definitely hold against him, and for suppression of material fact, an injunction can be refused. So these are the different factors that have to be balanced out against each other. Factors of equity and factors of consequence. And this is how we get the balance of convenience or inconvenience test explained. The third aspect is irreparable hardship. Now, what is irreparable hardship? In simple terms, it is hardship of the kind that just cannot be compensated by payment of monetary damages. So we really are speaking about a situation where if injunction were to be refused, the loss suffered by the plaintiff would be of the kind where he could not be compensated by payment of money. Again, let's go back to the hypothetical. The value of movie X is not necessarily quantifiable, and certainly not the remake value. A may decide to remake X in the same language as the one in which Z is being remade, and A may decide to have a better actor, A may decide to do it in a better way, or A may decide to do it worse than what B has done with Z. So it's very difficult to kind of predict the monetary value of an intellectual property right. And due to this inability or difficulty in predicting the monetary loss, in normal situations, we have to arrive at the conclusion that most injury caused in the field of intellectual property rights infraction amounts to irreparable hardship. Hardship that cannot be quantifiable in money terms. So once these three conditions are satisfied, the court can now say that there is a strong case for the grant of a temporary injunction. Now here too, there is a clear distinction between a prohibitory and a mandatory injunction. Now let us be very clear that both sorts of orders can be passed by the court even at the interim stage. There is nothing that stops the court from passing a mandatory direction rather than a prohibitory order. For instance, film Z has not been released. There, the relief sought by A would be to prohibit B from releasing film Z or conducting post-production work. But what if film Z has been released? Does the court have the power to take the film out of the theatre? Technically, yes. The court has the power to prohibit distributors from communicating the film to the public. That would be a prohibitory injunction. Or it can ask or direct B to perform certain tasks which ensure that A's right is not violated. So there can be a direction given to a party to do something. This is commonly done in the case of trademark violation, where two marks are identical or similar. The court feels that there is distinctive similarity, but it feels also that instead of prohibiting the party from using that mark, it can actually direct him to make a modification. The defendant can modify his trademark in such a way that it does not look distinctively similar to the mark of the plaintiff. That would be a mandatory injunction. You are directing somebody to do something. Now, mandatory injunctions are definitely riskier than prohibitory injunctions because you are actually asking a party to alter the state of affairs that he is in currently. And when the court does so, it has been held through a spate of judicial pronouncements that it must be extra careful and it must look at a very strong prima facie case. Unless it is convinced that there is a very strong prima facie case, or a strong case rather, more than prima facie, a strong case that the plaintiff is entitled to this relief, unless that's shown, courts will be reluctant to grant the mandatory injunction.